Good afternoon, colleagues. Imina 36 na legislature in Guam is back from recess. When we last left, we were with Senator Joe San Augustine. We will go ahead and I will get back with Senator Joe San Augustine. I know he had some concerns regarding the Safety Act provisions, but on the main motion, I'll go ahead at this time to address Speaker Therese Terlahi.
Thank you. Thank you, Madam Speaker. First, before I begin my remarks on the bill, I just wanted to state that this bill was reported out of my committee, the Committee on Justice, and on page 33 of that committee report, we did provide the entire statute, which is 9 GCA section 80.39, which is the provision that's being amended by this bill. Now, there was some talk earlier about the safety valve, and I want to admit that the words safety valve aren't necessarily mentioned in the statute that we are looking at in front of us. However, yeah, that's what it's commonly referred to when the law was passed, but it's not in the statute, those words. However, the statute involves sentencing, and it lays out that the court, notwithstanding any other law, may depart from the applicable mandatory minimum sentence if the court finds substantial and compelling reasons on the record that in giving due regard to the nature of the crime, the history and character of the defendant, and his or her chances of successful rehabilitation, that the imposition of the mandatory minimum sentence would result in substantial injustice to the defendant. And B, that the mandatory minimum sentence is not necessary for the protection of the public. And when I read that statute, it's a huge burden on the court to make these types of findings, Madam Speaker. And I don't think that they take this lightly. In fact, there's supposed to be a reporting requirement, but I've been unable to obtain any reports that indicate that a judge has departed from these mandatory minimum sentences. We're still working on it, but as of the date of the public hearing, there were no reports available to us to indicate that a court had ever actually used this statute to depart from those mandatory minimums. And so the exception statute that we're looking at would add, there's very few exceptions where the court cannot, utilize what they're calling this safety valve and depart from that mandatory minimum. And that's if convicted of a crime in the 10-year period, use of a firearm in the commission of the crime, or that caused physical injury, and the individual was a leader, manager, or supervisor of others in a continuing criminal enterprise. So this bill would be adding another subsection there that says, and first and second degree criminal sexual conduct. I looked at this so many times to try to figure the right way to go here, and I note that this doesn't include all violent felonies, murder. None of those are necessarily today included as exceptions to this, the law that says judges cannot depart from the mandatory minimum sentence unless they can make these types of findings. But as the sponsor, it has been shaken over and over, and not just, that incident that we're all familiar with, but many incidences of horrendous crime and victims telling us that they have not seen justice in their cases. And that's what we all want. We all want these crimes to stop. We want the victims to feel like we have heard them and we are doing anything that we can to address their situation. And yet, when I try to You know, our sentencing laws are complex. People tell us we have some of the strictest sentencing when it comes to criminal sexual conduct, and that our laws are strict. And I know this because we had several roundtables regarding criminal sexual conduct in particular in the last term, because of those shocking revelations that persons who had committed criminal sexual conduct were being released, right? And had recommitted the crime. And so through those roundtables, it was pretty clear, and I think agreed by most of the experts that were at the table, that this is a very unique crime, criminal sexual conduct. It is something that we were learning was not able to be rehabilitated in a prison at that time, and that we were very much likely to see repeated offenses if they were released, or danger to the community, and that we needed to do something about that, And so at the time, we did pass a couple laws that address release of prisoners, release on sentencing, release on parole, release on probation, release on pretrial, that no judge should release unless they could clearly say, after doing a criminal sexual conduct assessment, one that is particular to that type of crime, that the person would not pose a risk to the community. And so that's always been the standard, that they will not pose a risk to the community. And unfortunately, we just, it's one of those crimes. It's like at the end of their sentence, if we have nothing in our prisons to rehabilitate them, if there's really no science that we have brought to Guam to do this, and there are exceptions. There are some counselors that have come forth and said that that is exactly what program they are doing. And I just think we don't have enough on Guam, and we need, there's other aspects, I guess is my point, that we also need to shore up, right? If we are going to indeed protect our community. And the problem with this Safety Vowel Act, or making an exception to the Safety Vowel Act, is that the Safety Vowel Act, in other words, allowing a judge to use his discretion despite the minimum sentences that we are requiring by law, that came about because of many studies, and it was a federal law. So across the nation, they determined that they were going to allow judges some discretion on very, very, very rare instances, and in Guam, it looks like even rarer instances where I can't find that judges have availed of it. But in those very rare instances, they said mandatory minimum sentences did not deter criminal sexual conduct. It would not, doing this today is not going to prevent this crime from occurring. And that's the sad, sad reality, I think. We want to do something, but we can't prove that doing this is going to give us that result. And we can't look these victims in the eye and say, we did this, now you're going to be safe. Because that doesn't, all the studies have said, the studies that were relied on in order to pass this federal law said that the minimum sentencing guidelines were not deterring crime in general and criminal sexual conduct crime. They did it for other reasons too, because they were looking at other things that we are not necessarily looking at today, including errors in their, or marginal offenders, they called them. We're not looking at that today. Or they looked at, the cost to taxpayers for keeping people in prison. And I don't think we're looking at that today when we're talking about criminal sexual conduct. But it's just because it's been a consistent, I think, rationale in recent years to allow judges some discretion. And, we're all one to jump, I was the first, I think, when that incident occurred, was to get up and say, what are these judges doing? What are they doing? Why are they letting them out? And then, we have to examine our laws and find that it's just a complex situation, and at every sentence there's an end, right? And we are letting them out without anything intervening. And that's another one of the issues. And the judges are also, they did not at the time have, risk assessments that they could avail of, and neither did the parole board, and that was really important at the time. But in other words, if, this change is not going to deter crime or make our community safer from future crime, is taking away the discretion of the judge in these very rare cases where they would have to prove all of these things, that it was necessary to depart, then, do we want to do that? And I just find that with all the sentencing reform that has happened over the past few years across the nation, I think that's not consistent, that the reform has gone the other way. It is said to give the judges the discretion. In the public defender's testimony, as was read earlier by one of my colleagues, I take seriously these pleas by both the Attorney General and the public defender, because we need the system to work in order for justice to truly occur. And we need both of them to feel like they are able to bring any type of exception to the court if that is what the circumstances of this particular case require. And that, we're going to treat, individuals as individuals and not as blanket, that should also occur. So in the public defender's testimony, they said, there is no statute of limitations for a criminal sexual conduct charge. Guam's law on criminal sexual conduct is already among the toughest in the nation. Our prisons are filled with the defendants serving life sentences for such offenses. The Justice Safety Vowel Act encourages resolution of criminal offenses by avoiding trial. And this is a tricky thing sometimes even for me to understand. It's because they're talking about the dynamics between prosecutor, public defender, and what other solutions are there in these cases. So it says, it encourages resolution of criminal offenses by avoiding trial. It provides victims with a greater voice over the sentencing options of the judges. It encourages the reporting and prosecution of criminal sexual conduct offenses. In other words, the more we take away any discretion from the judges in these cases, the more people, individuals, victims might be afraid to truly turn someone in, because we can't control what happens after that. They can't have even a say. They can't, I don't know, but that's what they're saying, and I respect that they have been doing this for their entire careers, and that these are real issues. And so I want to just give that some consideration, that what is going to get us to the most reporting of these crimes? What is going to get us to the most taking them swiftly and doing justice to these victims, taking these people who might commit harm and swiftly adjudicating those cases. And as I said at our roundtables, it became very clear that criminal sexual conduct cases in particular, they are unique, they are complex. They're still debating, the effectiveness of intervention, but there are some that may work. But what we kind of concluded back then was that if we don't have that, then of course judges should not be letting anyone out of prison if they can help it, if they cannot make us safer after that imprisonment, right? If that's going to cause harm. So Madam Speaker. I just wanted to raise those concerns. I wanted to acknowledge that that we, we want justice, especially for these victims, especially in criminal sexual conduct cases. I don't think any one of us here disagrees with that, but I do think, the justice system is complex, and we need to find many different ways to solve this type of behavior, to prevent it from recurring, and to deter it, if that can be done. But thank you, Madam Speaker. And thank you to the sponsor of this bill.
Speaker Terlahi. Senator San Agustin, you did have the floor before we recess. I will acknowledge you at this time, but before you proceed, I just want to note that the Speaker Terlahi did note that the committee report, so I just wanted to make sure that you knew that it was duly noted. So I will open the floor to you. You are recognized at this time.
Thank you, Madam Speaker. After hearing my colleague, I was listening on YouTube as I was on my way down. I have no further comment. I'll just wait until we go to vote, then I'll decide then.
Senator San Agustin. Senator Tello Taitagui, you are recognized on the main motion.
Madam Speaker, for the opportunity to speak on Bill 8-36 COR. And I thank the good speaker for talking about the other, in the Safety Vowel Act, when it comes to regards to, here it is, just a minute, please. The other areas on A, B, and C in the Safety Vowel Act. And it mentions an individual has a conviction for the same offense during the 10-year period prior to the commission of the offense. Now, as I say this, think about the crime these sex offenders have committed, especially to the latest one, who's a 4-year-old child. The other one on B, Section B, that was just Section A that I spoke of. On Section B, the individual intentionally uses a firearm in a manner that causes physical injury during the commission of an offense. Think about that one. Compared to a child being molested or raped. How do you determine which is worse than the other? If you think about that, B again, during commission of an offense using a firearm compared to the rape of a child. That's in the Safety Vowel Act. That says there is no discretion of the judge in these circumstances. Look at B, Section B. C. The individual was the leader, manager, or supervisor of others in a continuing criminal enterprise. Look at the crime, the one that we want to add B onto. Sexual predators on our children. Which is worse? Where does it measure? Which is worse? Holding a handgun in a felony? Or somebody involved in a drug lord or enterprise? That made the cut on the Safety Vowel Act. That made the cut. If you all just balance this off, you will see, Madam Speaker, that this is important. This is a crime that none of us, none of our families would ever have to go through. Our children, our grandchildren. They talked about mandatory minimum sentences. And based on what I pulled up, it says the purpose of mandatory minimum sentences is to prevent the judicial trialization of serious drug crimes. Lack of certainty of serious sentences for serious crimes encourages rather than deters such risk takers to evaluate the level of criminal activity. So it does deter. Why do you think we have mandatory minimum sentences? It does work. We can't wait until one of our family members ever have to be in a situation like this. Some of us don't have connections at the judicial court to make sure we throw the book and send this person down for life if they ever hurt any of our family members. Madam Speaker, look at what's on A, B, and C of the Safety Vowel Act. I think that this crime on sexual predators, who, Madam Speaker, if you look at some of the statistics on it, it shows the repeated offenders. Majority of them become repeated offenders. So if we don't put this person away on the maximum sentence amount, then they may go out and do it again. Where are we now today if this bill does not pass? Where's your conscience then if this bill does not pass? I ask the body to please consider this legislation. It's about protecting our community. And although Bill 8 cannot erase the pain and hurt by our victims, what they experience, we can deter these repeated offenders. Thank you, Madam Speaker, for the opportunity.
Thank you, Senator. On the bill, Senator Duenas, you are recognized.
Jesus Mazi, Madam Speaker. Madam Speaker, I rise in support of Bill 836. You know, sometimes when I think of the good Senator, Senator Ada, what comes to mind, Senator Tony Ada, what comes to mind for me is the protector senator. Looking through his history of serving in this esteemed august body, he's introduced legislation with regard to castle doctrine so people can protect themselves. He was the champion years ago on making sure that we fought to get our taxpayers their tax refunds, protecting the integrity of the system and making sure that we don't cheat our people. Numerous other pieces of legislation. And because I know Senator Ada so well and the kind of father that he is, a great father, loves his children and they love him dearly, I can certainly understand why he decided to champion a bill like this. You know, Madam Speaker, I've oftentimes said to my colleagues as well that it's the bills that are introduced sometimes that have one line that are the most complex. They tend to bring out vigorous debate. But I think that it bears repeating what my good friend Senator Frank Blas Jr. and his time in public safety also mentioned on this floor, Madam Speaker. Relative to exempting individuals convicted of first or second degree criminal sexual conduct from sentencing reductions of the Justice Safety Vowel Act. You know, Madam Speaker, there's, other than a lot of the same things that Senator Ada and I enjoy, both in legislation and just hanging out as friends and family, one thing that I know of him more than anything else, as I said earlier, is just how much he cares. Because he served as the Director of Department of Youth Affairs like I did. We were just chatting earlier. Well, most definitely there is cases, and cases that are not, that are equally as heinous when it comes to sometimes juvenile behavior. They are far from the majority, at least during our time. And I mentioned that just because of the fact that I know there's this, even when and he probably had these issues too, when I was the director there always is that difficulty. Sometimes you have this back and forth between families and young people, as it was mentioned on this floor, sometimes making poor decisions. There's sometimes the information represented and the like is not altogether accurate sometimes, but that's why they got counseling and case management. That's why the juvenile system is constructed the way that it is. It's to work on these cases over time, and once again, as my good friend Senator Frank Blas Jr. said, the public defender's office, the prosecutors, it's nothing new for them to have to treat every case individually, and if it's appropriate, make those decisions prior to conviction. So, Madam Speaker, for those reasons, I believe that it's compelling enough to move forward and pass this legislation in the name of protecting our children. And I believe, as well as mentioned on this floor, if for some reason it becomes overly difficult, cumbersome, and we get reports, as you were mentioning earlier, Madam Speaker, in your testimony, that it's reported that we're having difficulty managing justice from the bench after these convictions, maybe the body will take it up at that time, but I'm going to go ahead and be on the side of making sure that we do the best that we can to represent a very vulnerable population. Just Masi, Madam Speaker, for the opportunity to rise in support of Bill 836 and thank the author for his caring, compassion, and desire to do the right thing. Just Masi.
Thank you, Senator Dueñas. On the bill, Senator Moreland, you're recognized.
Thank you, Madam Speaker. I heard a few of my colleagues, peace officers and myself. We have representatives of arresting authority, and we have representatives of incarceration peace officers too, all the way to the parole office. I remember my days when I was at the Department of Corrections as a parole office and interviewing these clients to complete their reports of what they've learned while incarcerated, and then to bring those reports to the parole board and for them to justify their case for early release. Not all the time, but most of the time, what I've seen is, when I first got working at the Department of Corrections, was I never met so many innocent people in my life, because it's always somebody else's fault. But in the parole report, you also have to interview the victim. This reminds me of the bill that Senator Ada proposed, reminds me of the one that stuck in my mind was a criminal sexual case. You would advise the victim of that the person that committed the crime against them is coming up for parole, and what do they think? On a CSC case, usually that brings a lot of tears to the victim. Some may just give written testimony, but there's also times where, you know, the victims are also invited to the parole hearing to testify. So, of course, we try to keep it separate, but it's really hard on the victim and the victim's family too. The CSC it's evil, right? In these cases, and really our job is to protect the innocent that didn't deserve this crime. So as we come to making our decisions on this, I just ask my colleagues to please remember the victims of these crimes and when making our decision. I thank you, Madam Speaker. Thank you to the author of the bill.
Thank you, Senator Moylan. On the bill, Senator Brown, you are recognized.
Thank you very much, Madam Speaker. You know, on a sunny day like today, and we go outside and it's a nice, warm, clear day on Guam, and we enjoy the tropical breezes, and we look at that beautiful ocean, and we look at our beautiful people, and one would never think that these type of horrendous crimes occur in our community. And they do. And every day we sit and look at the news, you watch the evening news, and goodness, almost half the news is taken up with who's been charged with this and who's been charged with that. And every day, every few days, you see another charge and another individual or individuals that have taken the innocent in our community who cannot protect themselves, who cannot defend themselves, and they've abused these innocent children. I can appreciate, as one of our former colleagues here mentioned about, young teenagers and budding love, and we were all teenagers once upon a time. For some of us, it was many, 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 many years ago. It's very hard to equate that with the realities on our little beautiful island of Guam, that these types of crime happen, and they happen repeatedly, and they happen to children of all ages. I'm sure none of us that have children could even imagine if this happened to our child or grandchild, what we would do. Because we spend so much of our time and our lives wanting to make sure that they're brought up, that they're prepared to deal with the world, that they're educated, and more importantly, probably anything else, is that they're safe. Many of us grew up at a time in Guam where we could get on our bicycle, and I used to do this when I was young, go with my friends and my cousins and ride all over the place. We just made sure we got back home at a certain hour, but we had that freedom. And it pains me that today, not that these issues didn't exist then, but we had a lot more freedom because we didn't hear or see these things happening as much. Maybe now it's just being reported, maybe because communication is more free-flowing. But we don't have that. And this is just one of a number of things that lead to the fact that we don't feel safe in our own community. But you hope, at least us as adults, that maybe we got a fighting chance to protect ourselves. Children don't have that ability to protect themselves. And they certainly don't have the ability to do it against sexual predators. And while, yes, it may be a very complicated process in trying to understand the psyche of someone that finds some sense of satisfaction or power by abusing a child, I think the majority of us in this community find this absolutely reprehensible. I certainly do. I'd do more than throw the key away if it was my decision, because I very much am troubled when someone abuses those that cannot protect themselves, those that cannot defend themselves, be it our children or our elderly or our disabled in our community. When you look at the charge of and conviction of a first or second degree criminal sexual action here, conduct that is listed here in this bill, and wanting to ensure that there is no latitude for the judge, is very representative of a sentiment that many people in our community feel as they see the continued crimes that happen to our children. You know, we're all familiar of hearing of the case that Senator Atta mentioned earlier that happened a couple of years ago. I think every time I drive by that street, I think about that child. Or the situation that just happened last year in one of our northern villages where a young girl was just walking from her house down the street to the store and was grabbed and was raped. Where are we for those victims that have to, not of anything that they did wrong, but because someone else harmed them? Someone else violated them. Someone else took their innocence and their childhood away. And this is happening in our own community, among our own people. As ugly as it is to recognize that, that is the reality. Certainly, from my perspective, like I said, I'd do more than throw the key away if it were left up to me. I think we need to send a strong message. And maybe we'll never figure out the dynamics. Maybe, you know, is this something treatable? Can we send someone to counseling? Can we rewire their brain? Can we make this urge or desire to do these type of crimes go away? I don't know. What I do know that I want to see is I want to make sure our children are protected from individuals like this. Because the fact is, if they're already convicted, they've already harmed someone or someone's out there. They've already committed a crime and harmed our people. I support this bill. And yes, you're right, Madam Speaker, maybe it doesn't prevent someone from ever doing a crime like this, but I'll tell you what, at least if they do, I'm going to feel some sense of justice. I will feel some satisfaction of justice, that they will serve their time. They will not be given any consideration to reduce their sentence. Because this is one of the most offensive things that could happen in our community. You know, one time I was asked to you get called when I was out of office. I'd been in office for so many years, I never had to worry about sitting in a courtroom and being a juror. My number was up, and boy, I was sitting there just angsting because I did not want to take the time of my day after day, call in, check in with the court. Did my number come up? And the situation essentially of what I was being asked, unfortunately, I got excused, but I had to go explain to the judge why I didn't think I could sit in this particular hearing for this case that was before us. Even though as time went on, I thought, hey, this is kind of interesting. I think I want to sit in on this case. I knew it involved violence, and I simply thought, if it involves family violence, I can't be unbiased. And I had to tell the judge that, sorry, I cannot be unbiased. Eventually, the judge said, well, you know, Ms. Brown, you're excused. But I just want to let you know this is not a family violence case. It had to do with two men that were fighting outside of a bar that had a disagreement. I thought, yeah, I could handle that. Family violence, I cannot handle. I can't handle that. Because I'll tell you, I'll vote to convict that person. Because anyone who's had to deal with that or has had someone close to them that has had to deal with that, even to the point of being murdered, it's very hard. Our people have to feel they have some recourse to justice in this community. And it's a challenge. It's something that happens every day. Sometimes people you least expect it that are being abused, and abused in their own homes where they should feel safe. Maybe it's the stranger on the street, or in some cases it might be the stranger that you think is your family in your own home. But it's not right, and it's not okay, and our children should have every right to grow up in a safe, healthy environment. We have no right to violate them. We have no right to tarnish them. We have no right to harm them. And taking this step, this very firm step to make this statement that this is not acceptable in this community, And if you go down this road, you suffer the consequences, and by all means, you should suffer the consequences. Our children deserve better. And I agree and wholeheartedly support this bill. I don't think there should be any latitude when it comes to the innocent in our community. Because if certainly we don't stand up for them, who's going to do it? It's certainly not these criminals in our community that have been allowed to continue to go out on the street and go back out and violate another innocent child. It's not okay. So with that, Madam Speaker, I do support this bill, and I commend the author for taking a stand once again to help protect our children. Thank you very much, Madam Speaker.
Thank you, Senator. Is there any other senator who would like to be recognized on the bill? If not, then Senator Atta, you're welcome to close. And we are returning now to your amendment.
Thank you, Madam Speaker. Madam Speaker, I'd like to make a motion to withdraw my amendment.
All right, on the motion to withdraw the amendment, is there any objection? Hearing no objection, the amendment is withdrawn.
Thank you,
Senator
Madam
Atta.
Speaker.
You may
Madam
close.
Speaker, I'd like to thank my colleagues for this healthy debate on Bill 8-36. You know, when we come together as a body, Madam Speaker, we come here to deliberate bills before us, legislation that has been introduced by each individual senator. But we get that from the community. We get our thoughts and our ideas from the community on what we need to do to ensure that our community is safe, that our people are safe. We introduce legislation that protects our coral reefs. We introduce legislation that protects our parks. We introduce legislation that protects people from themselves when we raise the drinking age to 21, the smoking age to 21. We need to come together to protect those that can't protect themselves. And those are the victims of criminal sexual conduct. You look at Bill 8-36, Madam Speaker. It's for the two crimes, first and second degree criminal sexual conduct. First degree criminal sexual conduct involves penetration, and second degree does not. And here's what's common to both. Once again, Madam Speaker, the victim is 13 or younger. 13. We're not talking about 17, 18-year-olds. We're not talking about 15 or 16. We're talking about 13 years or younger. The victim is 14 and 15, and the perpetrator is related to the victim by blood or marriage. The perpetrator don't belong in that house to begin with then. The victim is disabled. Who is going to protect our disabled, Madam Speaker, from these perpetrators? And once again, that was in the news just the other day. The victim is 14 or older, and an act of violence is used to accomplish the crime. As did that example when that perpetrator took the 10-year-old brandishing a gun. That's what we're here for, is to protect. Yes, we can't solve all the problems, but we need to try. We need to try to ensure that when children go home at night and go to sleep at night, they know they're protected within their homes. Because like my colleague said, let's not wait until it's one of our children, grandchildren, niece, nephew. Let's take action. And that's what this body is here to do, is to take action. And if 10, 15, 20 years down the road, the legislature then feels that it's not good enough, then they have the willpower to do something about it then. But today, this 36th Guam legislature needs to take action and ensure that we continue to do what is right to protect the vulnerable. I ask again my colleagues to please consider this. Because today, we're talking about this and debating this bill. And who knows, tomorrow, we'll see another case in the newspapers. Madam Speaker, I'd like to make one other amendment. And that's to add Senators Blas, Taitigui, Duenas, Moylan, and Brown as co-sponsors to this legislation.
On the motion to add the sponsors, is there any objection to that motion? Hearing and seeing no objection to the motion, motion is granted.
Thank you, Madam Speaker. We can move it down to voting.
Thank you. So on the motion to place Bill number 8-36 COR as amended by the Committee on Health, Land, Justice, and Culture to the third reading file, is there any objection? Hearing and seeing no objection, motion passes. We're now on Bill number 23-36. Assistant Majority Leader, Senator Shelton, you are recognized.
Thank you very much, Madam Speaker. I move to pass on file Bill 23-36 COR until Monday morning when we resolve into the Committee of the Whole.
On the motion to pass on file Bill 23-36 temporarily until the Committee of the Whole on Monday, is there any objection to that motion? Senator St. Augustine.
No, Madam Speaker, I don't have an objection, but at least advise the colleagues that there's 4 bills all in a row after 23, total of 4 that will be going to Committee of the Whole. And Monday, I'm in support of that. Thank you.
All right, thank you. On the motion, was there any objection? If hearing and seeing no objection, that bill's passed on file. We're now on Bill number 25-36 COR. Assistant Majority Leader, Legislative Secretary Shelton, you are recognized.
Sidis Masi, Madam Speaker, I move to pass on file Bill 25-36 COR until Monday morning again when we resolve into the Committee of the Whole.
Senator St. Augustine, can I just clarify, is that one of the bills? Oh, yes, all right. So on that motion to pass on file 25-36 temporarily, any objection?
Madam Speaker, can we just go ahead and list all 4 so we just can capture it all, or do we have to go one bill at a time?
Okay, I don't mind doing that. That's fine.
I can identify them
So
all.
you amend your motion, Senator
Yes.
Shelton?
Sure, I'll amend my motion, Madam Speaker, to also include Bill 40-36 COR and Bill 57-36 COR.
Thank you. On the motion to move all of those bills on the agenda until Monday morning, approximately 10 a.m., when we resolve into Committee of the Whole. Is there any objection? Senator Taitigui.
Thank you, Madam Speaker. Can you please repeat all those
Yes.
numbers? I appreciate it.
Got Bill 23, 25, 40, 57. All right, any objection? Hearing and seeing no objection, motion carries. So we are now on second reading, Bill number 33-36 COR. Senator Perez, you are recognized.
Sidis Masi, Madam Speaker. I move to place Bill 33-36 COR as amended by the Committee on Environment, Revenue and Taxation, Labor and Procurement, Statistics, Research and Planning on the third reading file, and I wish to discuss.
Please
Sponsored by
proceed.
myself. Thank you. So Bill 33-36, sponsored by myself, would require agencies to submit a procurement compliance report to the Office of Public Accountability in an effort to ensure adequate staffing of qualified professionals handling procurement at the agency level. The bill follows a recommendation by OPA audit identifying a need for more GovGuam employees to become proficient in procurement laws. Bill 33-36 is a natural progression of Public Law 32-131, which mandated training of procurement professionals to ensure personnel handling procurements are properly trained and make certain that the people of Guam will receive much-needed goods, services, and construction projects in a timely and efficient manner. Since the enactment of Public Law 32-131, protests and appeals were significantly reduced from 20 to 30 a year to 9 that were filed last year, totaling $202 million for various goods and services, including medical referral assistance, nutritional assistance programs, and ADA-compliant passenger buses. Currently, there is no monitoring agency to ensure procurement training compliance. With Bill 33-36, agencies will not only comply with the law in obtaining procurement training for employees responsible for purchasing, but they must also maintain that compliance. Procurement training compliance reporting could facilitate further reductions of appeals and protests. It can streamline procurement process by increasing the qualified personnel handling procurement at the agency level. It can maintain the standards of accountability and transparency and ensure goods and services that are of the right quality and quantity and obtained at the lowest cost overall and delivered in a timely manner. I would like to thank Public Auditor Cruz for his willingness to serve as the monitoring agency on top of the office's other duties, and I ask and thank my colleagues in advance for their support of this important reform measure. Mrs. Masi.
Mrs. Masi, Senator Perez. On the motion to place Bill number 33-36, is there any senator who would like to speak on that motion? On the bill? If not,
I'll
okay,
speak.
Senator San Augustine, you're recognized.
Madam Speaker, I stand in support of the bill. I'm just hoping that there's classes for them to attend, and they're able to complete the classes in a very timely fashion. But I'm in full support of the bill. Thank you, Madam Speaker.
Thank you, Senator San Augustine. On the bill, is there anyone who'd like to speak on the bill? If not, Senator Perez, you may close on Bill 33.
Thank you, Madam Speaker. Just a point of information. So part of this audit was communicating to GCC to ensure that training is back on track, especially during the pandemic. I think there was a bit of a delay and a lapse in that, but I think they're back on track with that. In addition, they're building up the program to ensure ongoing, continuing education for procurement. So yes, that was part of the recommendations of the audit from this.
All right. So on the motion to place Bill number 33-36 COR to the third reading file, is there any objection? Hearing and seeing no objection, motion carries. We are now on Bill number 45-36 COR. Senator Jose Pito Terlahi, you are recognized.
Thank you very much, Madam Speaker. I move to place Bill number 4536 COR as amended by the Committee on Health, Land, Justice, and Culture. Madam Speaker, Bill number 4536 is an act to amend Section 25.15C and 25.20C and add a new section of 25.25C, all of Chapter 25, Title 9, Guam Code Annotated, relative to mandatory minimum sentence for repeat sexual offenders.
Please proceed.
And Madam Speaker, I would like to move Bill number 4536 COR to the third reading file.
All right. Would you like to speak on the bill? Please do. You may.
Actually, Madam Speaker, yes, I would like to speak on the bill, Madam Speaker. Sorry. Madam Speaker, I was going down the line on the schedule for today's public hearing, but I guess this, we
We
went through.
rearranged it, yes.
Yeah, and
My
I was
apologies.
really not really prepared to go down. I was prepared to go down the line on what was scheduled. So just give me time to take a look at
Yes,
some
take
of
your
my-
time. Vice Speaker, point of order?
No, I'm his co-sponsor, and if he would allow me, Madam Speaker, I will share some thoughts on the bills in support and rise in support with him with the main sponsor. So
All
if
right,
he would.
If you could just,
yield-
we'll give him a little while
minute?
longer. Yeah, I think, we did rearrange the schedule. We'll just give a little while longer.
No worries.
Thank you, Vice Speaker.
Madam Speaker, if I may,
Yes, please proceed.
I introduced Bill 4536 COR to close a loophole in the mandatory minimum law for sex offenders. The bill would include criminal sexual conduct convictions from other jurisdictions when considering enhanced sentencing for repeat offenders. Currently, a repeat offender from another state can come to Guam and commit sexual assault and be considered a first-time offender because the conviction from other jurisdictions are not counted in enhanced sentencing bill. Bill 4536 CR would close this loophole and ensure that repeat of sex offenders spend a minimum of 25 years in prison for first-degree criminal sexual conduct, 15 years in prison for second-degree criminal sexual conduct, and 10 years in prison for third-degree criminal sexual conduct before they could even be eligible for parole. Madam Speaker, enough is enough for these sexual predators. No more loopholes, no more early release, and Jesus Masia. Thank you.
Jesus Masi. On the bill, 45-36, Vice Speaker Munya Barnes, you are recognized.
Situas Mahasi, Madam Speaker, for giving me the opportunity to speak on this measure as the co-sponsor with Senator Terlahi. And I just want to note for the listening audience, this bill intends to amend the sections 25.15 and 25.20 and to add section 25.25 to chapter 25 of sexual offenses, Title 9 Criminal Code from the GCA to change the mandatory minimum of years of imprisonment for criminal sexual conduct, particularly for those who are repeat offenders. I want to note that first degree of criminal sexual conduct is 25 years of imprisonment without the possibility of parole. The second degree is 15 years without the possibility of parole. And the third degree is 10 years without the possibility of parole. It also adds that those who have been previously convicted under Guam law or in other jurisdictions with the same elements that constitute sexual conduct or sexual penetration as defined in Title IX should not be counted as first-time offenders and will receive a certain amount of years based on the degrees of CSC. This bill does add that if any portion of the bill is found to be invalid, faulty, or contrary to the law, it should not affect the entirety of this bill. And the fiscal note was in, and BBMR did know that it was administrative in nature, so it didn't affect it didn't have a fiscal impact. And the Attorney General's office gave testimony in support, Madam Speaker, and they did have two sections that they noted on this bill, not giving a particular stance on the penalties, but noted the two items, and I'm just trying to get the amended version so I can see if those provisions were in, and if someone can help me just get into the amended version. I just wanted to see if section 2 of page 4 If you can allow me just 1 minute, I just want to make sure I get my pages right so I can get this up online. Madam Speaker, I just wanted to make sure that I thought there was a phrase that was missing, and I wanted to make sure that it wasn't omitted by mistake. So I just wanted to clarify the intent of the Attorney General and to make sure that the provisions are put in the amendment if it wasn't already in this form. So you can allow
Sure.
me
We will
just
take a
1 moment?
1-minute recess. Just 1 minute, please. We're back in session. Vice Speaker Munya Barnes, you have the floor.
Madam Speaker, for giving me the opportunity to consult with legal and make sure that the recommendations as provided by the Attorney General's testimony that we incorporated. And I want to thank you for your due diligence in the report of this, and thank you for giving me the opportunity to rise and in support and ask my colleagues to support the efforts. Sinamasi.
Sinamasi. On the bill, is there anyone else who would like to be recognized to speak on the bill? Senator Atta, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I am in full support of this piece of this legislation, Bill 4536. It just goes to show the will of this body, what we want to do to protect our children against first and second degree criminal sexual conduct from repeat offenders. And just as that is the groundwork for this legislation, we need to ensure that we continue to do good for our community, and that these types of strengthening what we currently have in statute continues to be our goal. Because the only way that we can protect our children and our community is to keep adjusting and amending the laws as we see and we move forward. We turn around and we repeal some legislation and we add legislation. So I commend the author of this legislation, Senator Pito, for introducing it, and I stand in full support. Thank you, Madam Speaker.
Thank you, Senator. On Bill 45-36, is there anyone else who would like to be recognized? Senator San Augustine.
Thank you, Madam Speaker. Yeah, I rise in support of the bill. I think the only thing missing on this bill, just like any other bill, like the bill before, is that everybody wants to talk about how we're protecting our community. How about if they're arrested, they're confined until they go to court, so that when they are in fact convicted, then they serve the time imposed by all the other bills. That's the biggest problem we have. But I'm in full support that if you're a repeat offender, you will spend some time. Thank you, Madam Speaker. Pido, Zao needs a mobile.
Thank you, Senator. On Bill 45-36, is there anyone else who would like to be recognized? Senator Moylan, you are recognized.
Thank you, Madam Speaker. Thank you to the author of the bill as well, another peace officer. Thank you for your service at the time with Guam Police Department, and I also enjoy hearing from my other fellow peace officers as well. We all have that passion for protecting protecting the people of Guam, especially, and protecting anybody from becoming a victim of this. I just want to add a little story that I do recall during my time at parole office, that we also had sexual predators, or rather CSE violators, who were semi-released to the island of Guam as well, and we had to monitor them too. So they're out there. So let's make sure, let's protect our community, and let's move forward with this bill. Thank you very much, Madam Speaker.
Thank you, Senator. Is there anyone else who would like to be recognized on Bill 45? Senator Taitagui, you are recognized.
Madam Speaker, for the opportunity. I do have a question to the author of the legislation. If you should
State your
yield.
question.
So the section that I was concerned about was on page 2, and it was on line 9, regarding the crossing out of 25 years. Section 2, 21-20, and this is letter C. Any person convicted of criminal sexual conduct under 25.20A subsequent to the first conviction of criminal sexual conduct under Guam law, or a conviction of sex offense under another jurisdiction that has an element that would constitute sexual conduct or sexual penetration as defined in 25.10, shall be sentenced to a minimum of, and it used to be 25 years. It's been crossed out in this legislation, and instead placed 15 years imprisonment and may be sentenced to life imprisonment without the possibility of parole. This is a big change, Madam Speaker, from something that we have in law that says a minimum of 25 years, now reduced by 10 years to 15 years imprisonment. So my question is, why the change?
Senator Terlahi, would you yield to that question regarding the change from 25 to 15 years?
Actually, Madam Speaker, you know, the crime is just, actually we should increase the time of imprisonment for people that have you know, done this type of thing, especially to our young people. So all I'm doing here is extending the lifespan of the sentencing. That's all that I'm doing here, to actually you know, correct the loopholes that has been happening on some of these predators of serving lesser time than, and I would think that they need to serve more time to teach them their lesson. That's all that I'm asking on this particular bill, Madam Speaker.
Thank you, Senator. Senator Teichwey, you have the floor.
Thank you, Madam Speaker. I greatly appreciate this piece of legislation that the author presented, but it didn't answer my question. The question was from 25 years and reduced to 15 years for the crime on a mandatory sentence. It still wasn't answered. So I guess if anyone else might be able to speak on it, then I greatly appreciate it, because I think the listening audience needs to know why it's gone from 25 to 15.
Senator Teichwey, would you like the Vice Speaker to yield to that question? She's
I
offering.
can try.
Senator Teichwey?
Yes.
Vice Speaker, would you yield?
I guess, Madam Speaker, I will try on this effort. I think it may have had to do with the difficulty with having to work with plea bargains, and that's why they lowered it to the second degree, but it added that provision that without the possibility of parole. So I think that was added. So I just wanted to make, and I hope that helps, because I think when they work this provision out and working with the AG's office, the committee felt that that would be an opportunity for them to extend without the possibility of parole because of the difficulty with the plea bargains. And again, that's just an assumption. I'm not sure based on the final reports, but that was what was noted in my notes earlier.
Senator Teichwey, you have the floor. Thank you, Vice Speaker.
Thank you, Madam Speaker, and thank you to the previous speaker trying to explain it. But, you know, I guess it's not just for myself, but the listening audience as to why this is happening right now. If it said that the Attorney General's office made those recommendations, you know, in their testimony, it should have been explicit as to why, instead of just doing it. So I thank you, Madam Speaker, for the opportunity.
Thank you, Senator. On the bill, is there anyone who would like to be recognized? Senator Torres, you are recognized.
Thank you, Madam Speaker. I attended the public hearing, and I also indicated that I would speak in support of the bill when it came to the floor. And I think that one of the reasons that I support it is what it does is it changes the conviction from someone who had been previously convicted of criminal sexual conduct to a person who is convicted for the first time. And I think that well, actually, let me take that back. I recall that, I'm trying to read the footnotes, and I'm not doing a very effective job at it, unfortunately, but I recall that what the AG presented was that rather than there are different degrees of sentencing, and what it did is it went to the more strict, where it had for subsequent, it applied that penalty to first time. So that was one of the more stringent effects of this legislation, as I recall. And I'm trying to find the AG's opinion, but I understand that that was what it was there was degrees of severity, and these amendments, in essence, made it more severe. And it had to do also with first offenses as opposed to repeat crimes. I believe he had a table here where he said there's, in page 2 of 3 of the AGs, he had a chart of relevant sentencing ranges, and he had current sentencing for repeat offenders, and it included only a prior first degree, and then it, for example, for first degree, it included 25 years to life only of prior first degree CSC, and under this bill, it would be 25 years to life for any prior CSC. So it kind of tied in the loopholes and incorporated any offenses there. So as I understand it from the AG, this was the more stringent of the range of sentencing guidelines. And I would just refer to the testimony that was provided by Levin Camacho, the Attorney General. So in essence, and I suppose in legalese sometimes it's hard to understand, but what he tried to say was that in the relevant ranges, this was the stricter of them, because where one had a criteria, only if this one made it applicable for any CSC, not necessarily just first degree CSC, but for any prior CSC. So I think that's the difference, is it applied convictions not necessarily just in the first degree, but any CSC conviction.
Thank you, Senators. On the bill, is there anyone else who would like to be recognized? If not, then Senator Terlahi, you are welcome to close on the bill.
Madam Speaker, before closing, I just want to mention that, you know, the bill itself is recommending a minimum of 25 years. So the 25 years might not be there. It might go even longer than that. Anyway, Madam Speaker, I just want to include Senator San Agustin, Senator Ada, Senator Moylan to be co-sponsor of Bill 4536 UR. Thank you very much.
Could you please repeat the names on your motion? Could you please repeat the names for the clerk?
Senator Joe San Agustin, Senator Ada, and Senator Moylan, Jim Moylan.
All right, thank you. On the motion to add those names as co-sponsors, is there any objection? Seeing or hearing no objection, motion carries. On the motion to place Bill number 45-36 COR to the third reading, is there any objection? Hearing and seeing no objection, motion carries. We're now on Bill number 52-36 COR. Senator Perez, you are recognized.
This is Masi, Madam Speaker. I move to place Bill 52-36 COR as amended by the Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research and Planning, and the third reading file, and I'd like to discuss.
Please proceed.
Bill number 52-36 COR seeks to require additional disclosure information to include financial interest, conflict of interest, and controlling interest of a prospective contractor with the government. Current statute limits disclosure of ownership interest to entities that were in existence when procurement laws were established in the 80s. Since then, new entities such as LLCs and potentially others not yet conceived are not included in disclosure requirements. Bill 52-36 will close this gap to include disclosure of any entity recognized in Guam statutes in order to ensure that the government knows who it is doing business with. Additionally, Bill 52-36 requires continuous disclosure should ownership change during the life of the contract. This practice mirrors federal practices that recognizes issues due to opaque ownership. According to a recent Government Accountability Office study that reviewed ownership of defense contractors, undisclosed ownership interest has and could potentially jeopardize sensitive security information and the quality of goods and services provided. Bill 52-36 expands disclosure of ownership to identify controlling interests of natural persons to the greatest extent practicable. The increased transparency of prospective contractors could also potentially identify if controlling interests were previously debarred or have not provided satisfactory performance for past work with the government. Bill 52-36 reinforces that disclosure of ownership, financial interest, and conflict of interest are a matter of responsibility versus responsiveness that is determined prior to award rather than at bid opening. Clarifying these two processes are necessary that could potentially prevent protests and appeals. In advance, I look forward to my colleagues' questions regarding this bill, and I look forward to their support as well. Sitzus Masi.
Sitzus Masi, Senator Paris. On the bill, is there anyone? Senator Taitakui, you are recognized.
Sitzus Masi, Madam Speaker, for the opportunity to speak on Bill 52-36 COR. I stand in full support of this measure. I attended the public hearing on it, and we talk about transparency and accountability in our government. And I think it should go further, even further than just contracts that come into play with the government of Guam. I think it should also go with sole sourcing as well, to find out who these individuals are who own these companies that the government of Guam deals with. It's about transparency on taxpayer funding that is given to these individuals, that the people of Guam should know what their taxpayer dollars are going toward. I think, Madam Speaker, there was allowing the 10% within any given time, greater than 10% at any given time during the 12-month period immediately preceding the date of solicitation is an excellent perspective in that time. I was questioning why only 10%, but I think that you'll be getting into going through paper after document and document, looking through things like that. So I think it would be very tedious, there'd be required more work than anything to look through that. But I think the 10% threshold is a good idea too as well. But Madam Speaker, we talk about every day where our taxpayers' money is going to, and this provides that information to the public, open and transparent. So I stand in full support of this legislation and thank the author for looking into something, a hole that's never been actually patched up when it comes to transparency. So I appreciate, again, the author of this legislation, and stand in full support. Thank you.
Thank you, Senator. On the bill, is there anyone who would like to be recognized? Senator Frank Blas, you're recognized.
Thank you, Madam Speaker. Madam Speaker, I understand and I support the intent of the legislation. However, in looking at some of the provisions of this bill, there are, I guess, some why concerns. And if the author of the legislation can yield to a question that can help me to determine basically my support of the piece of legislation. And if I can just go ahead and provide that question.
Senator Paris, would you like to yield to the question?
I do.
Thank you, Madam Speaker. Madam Speaker, the question relates to page 2 of the legislation, basically around line 22. Or it starts actually from line 19 to line 22, where it says, disclosure statement executed as an affidavit under oath, disclosing the name of each person who currently or has owned an ownership interest in the prospective contractor, bidder, or offerer, greater than 10% at any time during the 12-month period immediately preceding the date of the solicitation. I guess my question is actually in two parts. Ma'am, first off, what's the necessity at that point in time to know who used to own the company? The second question is basically, why 12 months? Why 12 months back?
Senator Perez, do you yield to the two questions?
Yes, thank you for that question. I do yield. And so the 12 months is actually in current statute, so that wasn't changed. In regards to the other element of who owned, I think, let's see. Yeah, I think it still mirrors what's in current statute. So what current statute says, that disclosure should include any ownership or any person who has held more than 10% of the outstanding interest or shares in said partnership, sole proprietorship, or corporation at any time during the 12-month period immediately preceding the submission of a bid. So in looking at the current language in the bill, I think it maintains that intent. It maintains the intent of who has interest in this company or prospective contractor, from what I can see. I don't know if that answers the question. It's original. It's originally the
So is it
statute.
am I made to understand that current statute states that? That it's presented to us in this bill as this is new language.
Oh, yes, thank you. Yeah, this is a repeal and reenact. So, yeah, it's not very clear, what parts were from the original statute. So, yeah, because if it's a repeal and reenact, everything would be underlined at this point. But that is what's in currently.
Senator Blas, you have the floor.
Thank you, Madam Chair. Again, the nature of my question was based on so what we're going to basically try to do here is repeal this section or this subsection in its entirety and basically rewrite it, recognizing that there's some of the provisions were remaining intact. Then it's easier for me to, I just want to make sure that this is not something new that we want to put in.
Are you asking the senator
Yes.
to yield? Senator Perez, would you like to yield to that question?
Yeah, yes, I do yield to the question. Yes, so I guess in the initial language of in the initial statute, it's pretty much a paragraph long, and what this bill does, it expands the disclosure to include additional information. And so the parts that were kept are the parts that are in question by the good senator. The expansion is basically updating the statute to address, what are the gaps in current law, which includes understanding the controlling interest of different layers within the ownership. So it's important to identify a natural person to the maximum extent possible, or who is actually controlling the contractor, or that has been awarded the bid. And so what this bill does, it really expands the initial statute to ensure that we know who we're dealing business with, and it just takes that germ of what this, and part of what is kept is what's being questioned. Is it really expands that to include other information, so that we can see that who we're awarding these contracts to. We can see who's controlling these companies. And one of the issues too is if the controlling interest is a contractor that did poor performance in the past or has been debarred, we need to know this, because, corporation names can change through time, or they can change the form from a corporation to an LLC, and LLCs are exempt at this point. So I think it behooves, it's part of it's part of practicing due diligence to ensure that, we're working with somebody who's going to be working with us in good conscience. And I think the importance of this bill too is that it requires a continuous disclosure. So that was one of the protests that actually happened in Guam, which held up, the contract for a long time. And so this would help solve that issue. Should a company change hands, we know now who is running this business and who we're dealing with. And it gives us the opportunity to, really monitor that, or, should we see that there might be some issues, we could potentially take the corrective action. So yeah, what this bill does, it takes the original law and expands that so to close some gaps and to increase the transparency.
Colleagues, we're going to take a 1-minute recess, please.
Please.
back in session. Thank you for that quick recess. And Senator, Frank Blas had posed a question. Senator Perez, you had yielded, and so we're about to go back to Senator Blas, but I am going to suggest that we take a recess on this bill, give it some in-depth review over the weekend, come back on Monday morning at 10. So if I'm going to recognize the Assistant Majority Leader, Shelton.
Thank you very much, Madam Speaker. I move to recess until Monday at 10 a.m. to conclude discussions on this bill, and then move to the Committee of the Whole for Bill 23, Bill 25, Bill 40, and Bill 57, and that the Committee on Appropriations and the Sergeant at Arms invite DOA, BBMR, and OFB to be present for all 4 bills, and that GPD be invited for Bill 23, and the Department of Agriculture be invited for Bill 25, and that GITA be invited for Bill 40, and GFD be invited for Bill 57.
Thank you. On that motion, is there any objection? Hearing no objection, we are recessed until 10 a.m. Monday morning.